Good evening, everybody. Thank you so much for the kind introduction and more importantly for the honor to be here and present some work we are doing at the MeDiMi research project. I will explain a little bit in a second what this project is about. But first and foremost, I would like to say I really enjoyed taking part to the extent possible in your fascinating lecture series, and I discovered so much overlap in research interests between your Kollegforschungsgruppe and our Forschungsgruppe. This goes well beyond the fact that we are funded by the same research institutions, but also in terms of substance. I try to refer to some of the presentations in mine, and now I'm here myself, so I'm really glad to meet all of you and talk to you about the discovery of migrants' human rights in the long 1990s, something that obviously needs some explanation what I mean by discovery and to what extent the 1990s play an important role as a transitional period. Oops. Okay, that doesn't work. How do I move forward? It's not the end. That one is the enter. Cool. Thank you so much. Okay, let me situate my talk briefly by way of introduction. Well, substantively speaking, the topic of my presentation is the emergence of human rights limits to migration control in the case law of the European Court of Human Rights. And I understand that the European Court of Human Rights has often played a role in your discussions so far, but not precisely the migration-related jurisprudence. That will be the focus of my talk. Why might that be interestingly to learn more about this case law of the Strasbourg Court? Well, there are at least two contexts in which precisely identifying when and how did that came about, this migration-related jurisprudence may play an important role as an argument. Well, first, there is a scholarly debate in which I'm also taking part that tries to make sense of more recent developments in the Strasbourg case law. In cases involving migrants' rights in one way and the other. And there are two prevailing views, some conflicting. One view holds that, substantively speaking, the court has always been on the side of the states and rather than the migrants. One participant in a MeDiMi conference we had last September called it, where all you can get in Strasbourg is just crumbs. So this view was even at the beginning of the entire legal discourse about this jurisprudence. Authors such as Marie-Bénédicte Dombourg, which wrote the first monograph on the jurisprudence, and Itamar Mann, and nowadays Thomas Spijkerboer, who has an ERC advanced grant on that topic based in Ghent. They all think there was always a statist assumption, a sovereignist bias in this jurisprudence, and it was highly overrated by many scholars. And therefore, it doesn't make sense to focus on these recent backlash events, which doesn't detract much from what was already there. And there's a different view that tells a story of a steep rise and a deep fall of the court that presumably has made a U-turn, so a sudden retreat from earlier jurisprudence, obviously reacting to political pressures from the convention states and arguably to a more hostile overall environment towards towards migrant, and this was held by scholars both from the legal field and also from people from the political science who have an interest in the politics of rights, and they mainly focus in making their steep rise argument in surprising findings that on case law of the years 2010, certain important developments such as the Hirsi case, I will get back to that case briefly later, or the MSS case, which the argument goes, has strengthened the rights of refugees in a surprising way. And if you like have a deeper look into how that came about, to find out that there's strategic litigation involved, that there is political campaigning surrounding that cases. And therefore the argument goes, there was a period of huge expansion and then the political reaction comes. It all goes down, and recent case law, for example, involving the barbed fences at the Spanish exclave on the African continent, where the court was happy to accept pushback practices by the Spanish government, and other instances were made for such a story of rise and fall. Well, at the end of my talk, I will present my own narrative, my own story, and how to make sense of the development of the case law. But in order to spoil it a little bit, I don't find any of the two convincing. I will come up with a third narrative on that. But there's a broader context which relates to the research interests we are pursuing in the MeDiMi project. That is a DFG-funded research group of 10 sub-projects from the legal field, from social sciences, from cultural studies, and we're aiming at an empirical-based theory of practices in contemporary society that we call, for want of a better term, or an established legal or theoretical concept, we call it humanrightization. Humanrightization that is taking place simultaneously in interwoven developments in law, politics, and in everyday life, in less institutionalized context. And in order to help you to get a grasp on our approach to that discursive practices in our contemporary society, I used a picture which was actually, if I understand it correctly, used for a share pic of advertising this event this evening. It has one advantage: this is copyright free, therefore you can use that for that type of purposes. But I was happy to select that one. I don't know exactly if everyone can read that, and therefore try to describe a little bit what I see on that picture. Obviously, a woman in some kind of activist context. She's not alone. There are others whom we not see exactly, and the context is not entirely clear where they are standing, in which context they make this intervention. But she looks rather determined, doesn't she? It's not only a strategic thing. So she's not calculating. She's expressing deeply held convictions. Yeah. And then we can read on the self-designed poster she has, refugee rights are human rights. And this argument, obviously, I understand from the context, is meant to say that this argument is actually strengthening the rights of these particular migrants rather than weakening it. So it doesn't say, well, they are only human rights. They are human rights, and therefore they should be strengthened in whatever context it exactly is. So she makes a claim that there is a human rights foundation of the idea of refugee protection. It's not entirely clear whether she wants to make a legal argument. It's a political moral claim, I understand. But if we look at the left side of her poster, well, we have these barbed wires. One of the iconic items of Amnesty International is a candle in the middle with this Amnesty International thing, but it also signifies borders and border fences and all this. Well, what these images tell us in this particular context. And then there is this, what's the English term?
Scale.
These scales. So since the Greek iconography was the symbol of justice, but also of law. So this, interestingly, whatever the context it is, she makes a reference to law. Is she a legal expert? Had she studied Hathaway's seminal book from the early 1990s, where he first has explained that we should translate one of the core concepts of refugee law, that is persecution, Verfolgung, into a legal term that means persecution is grave violations of human rights, and therefore, even for the first time in an intellectually made a link between the much older body of law that is the refugee law based on the Geneva Convention of Refugee Rights from the year 1951 to the much younger body of law that has developed starting, as you all know, in 48, the Universal Declaration of Human Rights. That was at the time non-binding declaration of policy intent rather than law, and it took decades until much of the substance of the Universal Declaration had embedded itself and entrenched itself in public international law. Had she made that statement in, let's say, 1960, that would have meant, well, refugee rights are just political talk. It's not law. Yeah, but I guess she is making the opposite claim. But that sees there's something has happened since then. So a process of legalization of human rights law, but more specifically, in the context of migration, well, a rereading of certain dealing with certain migration-related situations with the tools and with the arguments of human rights. So I find that interesting. So, and well, we all in this MeDiMi research group find these everyday practices, these frequent practices in our society interesting, these human rights driven dynamics of interwoven dynamics of legalization, politicization, and it's not proper English, everydayization, Veralltäglichung. We have one Native American speaker, she hates when I use everydayization because it's not doable in English, but still. So these interwoven dynamics of human rightization in migration-related conflicts is one of the things that concerns us. And as one of the things we have found out in these 2 years of doing research by now, with 2, or if the DFG funds us an extension for 4 or 6 years. Well, one thing we have found out so far that there's arguably 3 more structured conditions that makes it more likely that actors in migration societies refer to human rights as a normative resource, be it in the legal context, be it in the political context, or be it in a more non-institutionalized context, such as a social worker dealing with a refugee minor in his or her work, for example. So, and these conditions, we call them, it's human rights movements. If there is an infrastructure of semi-professional, non-governmental organization put in their effort in the field of migration, it's more likely that such claims are being made. So there's an infrastructure of human rights movements, established practices, and networking. And there is human rights consciousness. So there's a cultural element, a collective perception of self-understandings and of ideas of right or wrong. That was not always there. That is something that has emerged at some point, including migrants themselves make claims that are based on the assumption that they are bearer of rights. So that's something what they call human rights consciousness, and more to the point now, human rights law. That's our assumption. So the human rights consciousness, human rights movements, human rights law, these are, let's say, the infrastructure on which these human rightized practices, discursive practices, which we are empirically studying or doctrinally studying, emerged. And the obvious follow-up question is, when and how did that emerge? How did that come into being? That it's not something that has always been there. And at that point, we are missing historians in our project. When and how did that come about? And then a humble lawyer like me is doing the layman's job in doing some history, legal history at least. I feel more comfortable in talking about the history of certain judgments. They have dates and I have access to them, but still there's a historical question how this transformation has come about, involved in our project. And that's, well, that's the context in which I'm placing my presentation on certain developments in Strasbourg at the center of my talk today. I will proceed in 2 steps, 2, let's say, snapshots, pictures. The first snapshot is, in order to make my point that there is a fundamental transformation that has taken place that deserves to be explained, I will confront our contemporary today's societies, practices in them, with 50 years back. I will briefly focus on the 1970s to make the point that there's a huge difference between these 2 periods, or points in time, let's put it, that deserves to be explained how the transformation has taken place. And in the second step, I will focus more specifically on the contribution that the European Court of Human Rights, or practices that played out in Strasbourg, has contributed to that transformation, which I locate over the long 1990s, something that began in the late 1980s and was established or consolidated in the beginning of the new century, the long 1990s. Well, okay, let's go ahead. So just a brief snapshot that is essentially built on reading of historians' works of secondhand knowledge, and, well, the most important work which shaped our understanding of how human rights became what they are today is the work of Samuel Moyn, The Last Utopia. I'm aware that there's much debate on certain arguments he has made, so it's not uncontested, obviously. But still, certain core assumptions of that book, well, are essentially, I guess, uncontested. That is, that there was some conceptual rupture or leap that took place in the 1940s when the idea of human rights were not necessarily or preferably to be institutionalized at the level of the state. So that was the embedded assumption of the Republican Revolution, that rights should be institutionalized at the level of the state constitution, which should form the basis of that constitution, but rather at the international plane, so that human rights should form part of the international order. But second argument, essentially, that failed to succeed in the 1940s, and it took quite a while until practices unfolded that made that promise more or less true. And these time was the 1970s. And certain practices emerged at various corners of the globe, be it the Latin American, the exile from Latin American dictatorship, be it the dissidents in the communist bloc, be it these self-styled non-governmental organization, Amnesty International, that happened to receive the Nobel Peace Prize in 1977 and invented global campaigning as we know it today. So that is the characterization. I have some catchwords here of how human rights practices in the 1970s were to be characterized, essentially challenging totalitarianist rule, practices of transnational action, so advocating the human rights of people abroad. So, if you look into the discourse, how that was framed, essentially it was important for human rights activists or actors at the time to style themselves as not being political, in more specifically, not being either on the West or Eastern Bloc side, but rather being neutral as to the systemic conflict, but rather being claiming a normative resource that is beyond doubt. That you cannot justify torturing a non-violent person. So there's no need, there is no room for justification whatsoever, and therefore there is a very strong moralizing overtone in how politics were framed. Look at the same bullet points today. Today, human rights are used not specifically to challenge politics by authoritarian rulers and states, but also, and even preferably so, holding our own governments in liberal democracies and practices within liberal democracy or to account, using the language and the yardsticks of human rights. So therefore you can tell a story of a domestication of human rights, something that started in the national realm and lead to the international arena is now being back in the domestic arena. It's not about advocating for the rights of strangers abroad, but rather advocating for people, or in conflicts that take place within our society. Amnesty International at the time in the 1970s had a strict mandate, not intervene in any political conflict in your own section. Today they do so on a regular basis. Okay? And obviously there has a process of politicization of human rights taking place. Human rights are nowadays used to make highly aspirational normative claims, and highly contested political demands are being made using human rights. A certain treatment of persons, well, that's well beyond within the reach of what can be decided politically, which is necessarily politically contested. So there is not this all-time minimalism of human rights of being something you cannot dispute, but rather, well, a human rights maximalism, making highly aspirational claims using the language and human rights. And last bullet point, legalization of human rights has taken place. And well, if you claim that human rights should form the basis of policy, you are confronted with the counterclaim that you are advocating a rule of judges, and that politics should be legalized rather than moral. Legalization is one of the signifiers of nowadays human rights discourse. Well, That should be minus, right? Well, you can read. Okay. There's one interesting observation turned into migration. There's one interesting observation in the entire book by Samuel Morley. There's but a single example, only one. So hardly any. Only one example where the various practices of human rights activism and human rights claims being made and human rights ideas being circulated relate to issues of migration, to migration-related conflict. And they did exist, that type of conflict. It's not that there was nothing to debate, but it was simply not an issue of human rights for actors at the time. The single example is the advocacy for Jews in the Soviet Union who were denied the right to leave the country, something that is recognized as a in the Universal Declaration as a human right. And certain advocates at the time were using the new language of human rights to making this point in order to help the Jews in the Soviet Union, rather the Zionist language that had been used to support the Jews before. That is the refusniks at the time, and Moyne tells us about the relevant activism of the American Jewish Committee. But I learned from your presentations here, so that is that there's quite some Western activism on behalf of the Jews, and your colleague Ida Richter has informed us about. Hi. Excuse me, that I didn't recognize. You made the point that the 35s were at the time, well, using human rights language, and you had a different research question how that connects to Holocaust memory, but you identified there is a transitional period taking place in the 1980s, something which I, from my field of knowledge, can support. But that's the only example of a migration-related conflicts that was dealt with in the language of human rights at the time, to my knowledge, at least a more prominent example. And even that example is telling in itself. Well, migration-related conflicts today are almost always about people demanding entry and stay rather than the right to leave a particular country. So it was a different world. Well, that's the obvious case. We all read LinkedIn, Instagram, or Tagesschau. So reference to human rights are all over the place in migration-related conflicts, at least on the side of actors who advocate in favor of inclusion of migrants. Inclusion used here in a very broad sense, be it territorial inclusion, be it inclusion in social systems, or be it treatment on an equal basis. So in their practice of these actors advocating inclusion of migrants, human rights are everywhere. In law, as a legal argument, in political context, as a political moral demand, and also in non-institutionalized context. And that is what we need to explain, what we have to understand, how this transformation came about. Okay, I move on to the second snapshot. That is the one focusing on Strasbourg and the contribution that the European Court of Human Rights has made to bring about what I have called this condition of possibility human rights law as an essential infrastructure for that type of human rightization taking place in our society. I can be very brief on that slide because I'm in a room full of experts of human rights, so I don't have to explain much about what the European Court of Human Rights is. Just a brief reminder, it's a Strasbourg-based court, which is a judicial body of a pan-European institution, the Council of Europe, and it has compulsory jurisdiction to hear claims from victims of human rights violation after having exhausted the domestic remedies available to them. And the court understands this document, the European Convention of Human Rights, as a living instrument. That's something that has to develop over time. So therefore, its practices do not only refer to what was the meaning of human rights at the time when this convention was being ratified by states, but rather tries to find answers to what human rights should mean in our contemporary society. This particular court, and that's one additional information from a lawyer's point of view, you cannot overestimate the importance of that jurisprudence for rights-related jurisprudence all over Europe. Almost all highest constitutional courts, including the Court of Justice of the European Union, accept a leading role of that court when these highest national courts interpret their own domestic bill of rights. Okay, what deserves a little bit explanation, however, might be the nature of case law. So not all of you in the room are lawyers, and there's some often misunderstandings of the nature of case law. I just would like briefly mention that here. Such highest court like the European Court of Human Rights, they don't decide cases. Yes, they do, but that's not the point. And they don't provide legal protection to individuals. Yes, they also do. But the main thing what they do is shaping the law. They develop an interpretive practice that gives meaning to a document that is the law as it stands, but the meaning of that law is essentially developed by the court itself in the discursive practice involving other actors as well, including legal scholars, but still. So there is such a high degree of latitude by courts like the European Court of Human Rights that the text itself hardly determines the outcome of the jurisprudence. And jurisprudence, Rechtsprechung, in that context, is not simply a statement. It's about building lines of cases. So establishing something as a precedent, as something that has some kind of determining force for the future. It's more like the work of a script writer of a movie series who has some kind of, well, beloved actors and that have found their audience, but you always have to develop the story. And by determining the future, the characters of the actor, of the proponents, or something, events that take place, you always have to look back what you have said before on the same story. If you invent in episode 5 of season 3 of such a series that one of the main actors actually has a brother, well, you change the past. And if you introduce new side roles, you have to keep this system consistent. So you always have to do the job what the screenwriters call continuity. You develop the story, change the past, and then you said, well, yes, we have a new statement, but we have said so before. Look, there was an unknown case before. And there's so much possibility how the law can develop that is enshrined in that past, that it's an open process of meaning making by way of interpretation. And therefore, discovery might actually be appropriate term is if innovation was being made, although the text on which this interpretation refers has actually not been changed. I will demonstrate this process with two particular provisions of the European Convention of Human Rights. It's Article 3 and Article 8, and you can say these are the cornerstones of today's migration-related jurisprudence of the European Court of Human Rights. And obviously, I will not go into the details of that case law and that jurisprudence. Please accept my summary of that jurisprudence, and we can go into details of the argument if you so wish. But please note that none of these two provisions, the provision of torture and the protection of the right to family and private life, refer to migrants of any sort. They are migration-blind provision, but that was the raw clay from which the European Court of Human Rights has formed a migration-related jurisprudence. Briefly on Article 3 and when it all started. Well, the beginning, undisputedly so, is the Söring case. Mr. Söring and his loved one were on the run because they arguably had killed the husband of hers. They were caught in the UK and United States of America, made a claim for extradition, Auslieferung, towards the UK. And Mr. Söring claimed that that would amount to a violation of his human rights because he would face death penalty, US, if being convicted. Well, at the time, the prohibition of death penalty was not yet fully settled, even within Europe as in recognized human rights. That was kind of difficult for the court to base his judgment on the argument related to death penalty. But he found this Article 3, this prohibition of torture and inhuman, degrading treatment or punishment. And he said, well, sitting in the USA in the death row, not knowing when you will actually be executed, that amounts to treatment that is similar to torture and related. So Article 3 was used as the source for Mr. Söring not to be extradited to the US. He actually was when the US dropped the charges of death penalty. He was convicted for 30 years and has by now returned. Okay, but still, there was an argument being made, being tortured, I simplify, by a non-convention state, here the US, amounts to a right to stay within a convention state, something which technically is called non-refoulement. There was the idea that for the first time in the jurisprudence of the court, that the principle of non-refoulement, not being delivered to another jurisdiction where you face certain treatment, was derived as an implied right from Article 3. And that today is the cornerstone of refugee law in Europe. This case could have been something specifically to do with criminal jurisdiction and with death penalty. But the court decided only a few years later that the same logic applies to refugee-related cases, where it's not about death penalty, not about being convicted, but rather being subjected to a particular treatment that would amount to grave human rights violation in another country, when one of the convention states would use his immigration law machinery to transfer this person to another country. That was the Urknall, that was the very beginning of something new, that there is an implied prohibition of non-refoulement in Article 3. And from there on, a highly complex jurisprudence developed. I will not go into any details of that. This principle of non-refoulement implies an unconditional right to stay. Well, it also applies in cases of chain refoulement, where you cannot be transferred to a country which would likely transfer you to a country where you would face that grave human rights violation. And most importantly, it applies also in border situation. It actually amounts to a right to be admitted. Claiming asylum at European borders today gives you a right to access, if only for the purposes that your claim is being checked whether it is well founded, but it gives you access to the territory. That's Article 3. That's all built, the legal constraints on European refugee policy at the external borders is all being built on Article 3 as it emerged from the serving jurisprudence. Yes, more recently, I jump over here. More recently, there are signs of some partial retreatment by the European Court of Human Rights in border management cases, but I tend to argue that they do not touch upon the core of that jurisprudence. I'm happy to explain that in more detail if you wish. Still, as the law as it stands today, the Strasbourg jurisprudence as it stands today, well, gives you an enforceable, unconditional right to asylum, including at the borders. Well, based on a text where precisely the right to asylum has not made its way into the body of the European Convention of Human Rights. Human rights have become the foundation of refugee law, so that's the legal development that corresponds to the signpost of the women which I showed in the beginning. Yes, human rights are the conceptual foundation of refugee law today that has also materialized in a complete reinterpretation of what the Geneva Refugee Convention of 1951 actually. A very parallel story, parallel in terms of timing, but also in terms of substance, can be told when referring to another sovereign prerogative of states. Once granting asylum was a sovereign prerogative of states. Now it's a human rights of migrants seeking protection. Once expulsion, Ausweisung, was a sovereign prerogative of states based on their territorial jurisdiction. Well, yes, international law since the 19th century enshrines some basic minimum rights of aliens while being present. You have the right to be recognized as a legal person and Enteignung. What's it? Expropriation must not be arbitrary. So you have in a German legal saying, you have the right, mit Sack und Pack das Land zu verlassen. You have the right, you must not be expropriated, but it's a discretionary decision of the state to grant you the right to stay or not. The state can expel you any time, and there's no rule in public international law that prevents the state from doing it. That's where we come from. Here comes Article 8, the right to respect of family and private life, which is obviously prima facie silent on expulsion. It doesn't say anything about expulsion, but still the court has accepted the idea brought forward by certain claimants that the wish to live together with close family members and the wish to develop your personality as part of your private life at the place of residence, at the place of your own choosing, is protected by human rights law. It all started with Berehap versus the Netherlands. It's a heartbreaking story, and if I understand it correctly from the reading of the case and the materials around it, that Mr. Berehap was a kind person, a Moroccan nationally that married a Dutch national, and they had a nice child, and he was caring. He loved both of them. Originally he had entered on a work permit, so he was an economic migrant. Then they married, but well, life happens. The marriage break down. The couple divorced, but they agreed on, which was certainly not obvious in the 1980s, both to care for little Berehap. But the Dutch government at the time was pursuing, also at that time, was pursuing a highly restrictive policy. They had the idea of returning migrants who have no legal argument to stay or no economic rationale to stay, and well, being admitted on the basis of being a married couple was not an argument anymore because the couple had divorced, and there was no obvious need because, well, even at the time there was no Skype or whatever, but from time to time you could see they could meet in Morocco, the Dutch government. There's a background story behind that because there's quite some legal activism going on even in the 1980s. So at the time, who well appealed to a notion in the rather conservative Dutch society that family should be high value, that you should enable these, today we would call it patchwork family, somehow live together, enable permit Mr. Berehap to see his child on a regular basis. That would be something that is also in the best interest of the child, as we call it today. Well, the Dutch court didn't like that argument. Well, the Dutch government had said otherwise. But there were activists desperately seeking for a court to hear this claim. But actually at the time, in expulsion cases, there was not a single legal avenue to find a Dutch court to which you could go through. And so I said, well, there is this European Convention of Human Rights. Let's try that one. And they made a campaign. They had the yellow RV, so they called it the Juspus. That was a practicing lawyer from Amsterdam who drove all over the Dutch countryside and made the point, brought legal advice to refugees and aliens in these remote areas, part of the Rechtswinkel movement at the time, so having community-based legal consultancy. And they eventually brought this Berehap case to Strasbourg. And they won. The court said, well, you cannot disrupt this family. No way. And then the Dutch courts gave in and gave him a permit. That's where it all started. Legal arguments, civil society activism, also a particular kind of consciousness that had developed that even aliens have rights, fundamental human rights. That was something that emerged over the 1980s and legally materialized well in the year 1988. And from there on, an entire line of jurisprudence developed, and a complex jurisprudence, which I also cannot explain here in details. It amounts to, for example, to a prohibition of automatic expulsion of criminal offenders, something that very many jurisdictions had at the time. When you commit a certain crime, you're out, without looking into the individual case, without any balancing or seeing whether it is a fair treatment of this particular situation. The court said, well, no. Under Article 8, there always have to be a fair balance being struck. You have to look at the individual case and listen to what the people say, what that would do to them if you disrupt the family. And therefore, under the European Convention of Human Rights, there is no such a thing as automatic expulsion following a criminal conviction anymore. Well, then there was these cases of the people who were not minors anymore, but were still stupid enough to commit juvenile crimes. But they had no family claim to being made, although they were born in the country. These second-generation migrants who know the country of their parents from vacation. Can you kick them out because they are offenders? The court said, well, family, it's not the issue here. They are singles, don't live with a parent anymore. But they have developed ties to that society, Germany, to the Netherlands, to France. All countries that tried to push out this offender at the time. The court said, well, developing those ties at the place where you actually live is part of your private life in the meaning of Article 8. And therefore, the same argument that had been developed for the social ties among family members was extended to essentially all relevant social ties developed at the place of residence, be it business relations, having your own childhood in a particular country, your friends. That's protected by human rights. It's not an unconditional right. There can be public reasons to expel you anyway, although you do have a family life or you do have a meaningful social ties at the place of residence, but always they have to be balancing at the individual. That's a general approach. And one of the very notable cases is this Judgements versus the Netherlands, where it was actually became clear that in certain situations, and arguably rather exceptionally, there's also a right to be regularized. That's not only a right of someone who, like Mr. Becher, but was a legal migrant in the first place. The same arguments basically also apply to irregular migrants. You cannot simply kick them out without looking as to whether they have meaningful family and social ties developed. The hurdle is higher, of course, because they have entered illegally in. But, well, the Judgements family, Dutch authorities knew that the one non-Dutch member of the family of Suriname's nationality was actually staying in the country for 13 years and 3 children. And they were married. And the Dutch authorities said, no, now you have to go. And then the court said, no, you have to give her a residence permit, regularize her stay, based on Article 8. I'm stressing the importance of that type of jurisprudence here in order to make the point that this is a huge development as compared to the law as it stood before. It amounts to something which I would call a legal cultural revolution. Completely changes the game, how the law treats migration-related issues. In this particular case, there is an, of course, conditional human right to sojourn, a right to stay in all but name. It can be balanced against public interests. It's conditional, but there is the interest of a migrant in staying is protected by human rights law. That's amazing. So you can argue that human rights has become a source of denizenship, of belonging beyond nationality. Okay. Having made my point that was a huge leap forward that took place at some point in the late 1980s, and that consolidated in a newly built chain of jurisprudence over the 1990s, and it was established law, gefestigte Rechtsprechung, at some point in the beginning of the years 2000. I could name the cases where the court summarized what he has said before and therefore made a new, well, draw lines of what the law is. At some point in the beginning of the years 2000, that was established law. And therefore, well, we have to recognize that well-established instruments of migration control, age-old instruments of migration control, discretionary asylum, discretionary expulsion, are not purely within the discretion of pure discretions of state anymore, but rather they can be challenged at practices by migrants claiming their human rights and, well, the particular circumstances of the case, and obviously also the power relations at the time will determine the outcome. So making this claim does not necessarily mean that the claim is successful, but there is no, well, I would rather argue in the positive. The court has opened up a space of possibilities to challenge migration control practices in the name of human rights, and that I would call a cultural revolution within the law. But, so therefore, those people who say, well, you only get crumbs and stuff, they miss the point. They have no historical deepness, how things were where we come from. But the story that there was an ever increasing progress at Strasbourg is rather naive. And obviously it did not take place only in the year 2010 in the Hirsi and MSS and some other outstanding cases, but rather the transformative period was the 1990s. And after that was consolidated jurisprudence, there was no ever more progress in Strasbourg. There was always compromise finding, and there's also, well, then back and forth. Well, sometimes you win cases, sometimes you lose cases, sometimes you have a chamber with a daring composition, sometimes you don't, and sometimes things get reversed. There's a power struggle going on with legal arguments. And, well, the government has to speak the language of human rights law in that forum. They cannot simply exercise power. They have to justify their restrictive practices in the language that is compatible with the human rights law. That's the difference, not an ever expansion story. So therefore, my story would be, well, there was a transformative period and the transformation was substantial over the 1990s. But then we have reached a certain level where you have a back and forth development, and I would explain these more recent restrictive cases, well, in line with this back and forth dynamics that plays out in Strasbourg. But yet again, for the time being, as things stand today, the court did not sanction a return to the ancien régime. So those people, though there was not such a steep rise as some people might think, but there's also not such a deep fall as people might think. The essential building blocks of the jurisprudence that have been developed over the 1990s are still in place. These cornerstones still stand, and also the procedural avenues to claim. And therefore, I would argue, as long as these essential condition of possibility for human rightization to occur, it's likely that human rightization will take place also in future. It may also, let me finish with a zeitdiagnostischer Beobachtung, with a diagnosis of our time that obviously is not methodologically strict. Well, there are restrictive practices and they are increasingly restrictive. Obviously, you all follow the news. The legal argument has a hard time these days against powerful restrictive policies and practices. But the real challenge is not the politics and the policies of the day, but rather as to whether the conditions of possibility that have come into being over the long 1990s, whether they are disrupted or not. Much more dangerous than the resolution by the German Bundestag that is obviously illegal and against human rights law. Much more dangerous is the more quiet proposal by a former minister, Mr. Spahn, who said, well, let's withdraw from the European Convention of Human Rights. Can humanrightization be undone? Yes, it can. It came into being, it can be undone, it will end at some point. But to end on a more optimistic or happy note, as long as these conditions of possibility, this human rights infrastructure is still in place, seems highly likely that humanrightization is here to stay.